Hi all. Welcome to another X Space hosted by DIAG, Democrats for an Informed Approach to Gender. I'm Ellie, DIAG's Executive Director. DIAG is a 501c3 nonprofit organization of lifelong Democratic voters. We are working to shed light on the medical scandal and the erosion of women's rights that are the direct results of gender ideology and sex denialism. We're building a movement to correct what has been the prevailing narrative around the experimental, dangerous medical practices of sex trait modification, what's euphemistically known as gender-affirming care, and clear the path for a safer, saner, evidence-based response to gender distress. Please visit our website at diag.org and also check out our merch store. And if you'd like to help us continue and expand the work we're doing, please hit the donate button. DIAG believes in the liberal values of free speech and open discussion. This is why we host these spaces, to invite conversation on topics that have been left out of the public discourse. The opinions expressed by our guests are not necessarily the opinions of our organization. If you follow this topic, you know that there are lawsuits in the works. And about a year ago, we spoke with our guests about the status of those lawsuits and the legal strategies applied. Today, we're going to get an update. Back with us are Kevin Keller and Kathleen Dooley. I'll let you both introduce yourselves. Kevin, let's start with you.
Great. I appreciate the invite and the opportunity to speak with everybody again. My name is Kevin Keller, and I am a lawyer who has defended catastrophic loss civil litigation, mainly on behalf of insurance companies, for about 30 years now.
Okay. Also joining us, Kathleen Dooley. Why don't you introduce yourself?
Hi, and thank you. Happy to be here. Excuse me. So I'm a recovering attorney. I practiced law for 35 years. About half of that in my career was spent working with insurance companies. I am also a member of Democrats for an Informed Approach to Gender, but my views today are my views and not the views of the organization. So as a defense lawyer, because that's what I did for 35 years, I also know how defendants think. I am also the daughter of a man who was a plaintiff's attorney for more than 60 years. He did medical malpractice cases plus other cases that were cases of first impression. So I could see when they got dismissed from the outset how through sheer tenacity, he and others were able to break ground to make new law. And so when we talk tonight, I just want to share with everyone, but this is how this feels to me. Thank you.
Hey, welcome, Kevin and Kathleen. Nice to have you both back. Kevin, I'm going to start with you. A little bit of a personal question. You've made a career defending clients against claims of harm. Your clients have not been medical practitioners fighting claims of malpractice, but insurance companies and manufacturers facing huge judgments in product liability cases. So how and why did you get involved in this cause, helping plaintiffs get justice from the medical practitioners?
Sure. So my practice involved not just products liability claims, but really any large lawsuits, large losses against anybody for almost any reason for which you would have liability coverage. So it could be a building collapse, it could be a plane accident. I've defended a number of aviation cases as well, large fires, all that kind of thing. And after doing that for 30 years, this latest wave of gender dysphoric related care caught my attention as a parent, somebody who has 3 children, and including a teenage daughter. And, at the time, a young son in his early 20s and another son who was, I guess at the time I started looking at this stuff, say about 13 years old. And I just thought it was just so odd and so shocking to the conscience that people would be allowed to do this type of surgery on individuals. I've also done med mal. So I've defended medical malpractice cases for years on behalf of insurance companies. I haven't done it in a while, but I did it, let's say 20 years ago. And by the way, my wife's a plaintiff's lawyer, so I've seen her pursue that as well. At least she did it for about 10 years. She's a stay-at-home mom now, but she feels very strongly about it as well. So, when I started seeing this phenomena arise, this kind of anomaly, it was shocking to me, and I just couldn't help but think, well, there's obvious litigation that should come from this. There's obvious medical malpractice cases that should come. It doesn't take much sniffing around this type of care to know, even 3 or 4 years ago, let's say 3 years ago when I started looking at it, before you saw all the articles on this, the lack of evidence supporting this care, all you had to do was sniff around a little bit to see, well, there's nothing to support it. How can a doctor recommend this? I don't understand. How can that comply with the standard of care, which is what I'm always looking at, as a lawyer, as a defense lawyer. How did my clients violate the standard of care, regardless of what kind of lawsuit it is? And then also, what's become obvious is, how could there ever be informed consent? How can they know whether this experimental treatment is going to be harming people, youth especially, in the long run? So it just offended me, frankly. I thought it was a great evil, and I wanted to do whatever I could to throw myself into, and I do it pro bono, into helping and promoting viable litigation against organizations that deserve it, to help vulnerable people who are harmed by experimental medical care.
Okay, I want to get Kathleen's side, how she wound up, and also, talk a little bit about Themis, and then I have a comment about that.
Sure. So, I became attuned to this for various reasons, but yes, I share what Kevin Keller has witnessed, and also, referring back to my dear old dad again, God rest his soul, he was involved in the DES cases. I can't pronounce that drug, but that was a drug that was given to women back in the 60s who had morning sickness, and they ended up with daughters who had fertility issues. You also have the thalidomide, where the doctors were prescribing that, and then you had children being born without limbs. And then the other thing is the natal X-rays. Women in, I think, the 50s or 60s, pregnant women were being X-rayed, and so the babies ended up with leukemia. And so we've seen time and time, and not to mention lobotomies, but this has really resonated with me. And the more I learned about it, the more concerned I became about what's going on. And so with Themis Resource Fund, Themis is the goddess of justice. And we believe that this growing cohort of young men and women who regret the irreversible things that have been done to their bodies, they deserve, it's very, very difficult to get a medical malpractice or any plaintiff's case off the ground. It runs into the six figures just to get it to the courthouse and file it as a complaint. And so we know that many of these young people don't have the resources. And so what we do as a tax exempt organization is we solicit law firms and we solicit plaintiffs, or have you been harmed? And then we ask people to donate, and we help provide funding for these lawsuits so they can get off the ground, so they can get to the lawsuits. So that's why, again, going back to my experience growing up with a man who did this for a living, that's why I'm deeply, deeply committed to seeing seeing these cases get to court and to seeing these young people get justice.
So, I guess my comment is, no attorney that I've spoken to, and I've spoken to several at this point, no one that I know of got in because they thought that they were going to make a killing on this eventually. That was never the motivation. And, but, I think that, that should be true because it's such an awful scandal. And anybody who looked at it, even in the early days, could see that this harm was going to have to be, this was going to have to play out in the courts. So, but yeah, no one came in it saying, I'm an early investor, basically. So, as involved observers of this legal fight, can you just give us an overview of where the battle stands? How many cases have been filed against gender clinicians, and are any of them close to a verdict?
Well, we're aware of about 20, and if you go to the Themis Resource Fund.org website, we've got a list of the ones that we're aware of at this time. I'm sure that there are more being filed. And, you know, for anybody, for an unsophisticated litigant, these cases are not resolved in a year or 2 years. They can take 3 to 5 years. So they're winding their way through the court system. And Kevin, jump in any time, but this is typical. I mean, we don't have any that are going to trial this year that I'm aware of. We do have the one case in North Carolina, which I think has gone farther than the other cases across the country, and so we're keeping a close eye on that case. Kevin, what do you think? I mean, the wheels of justice turn slowly, right?
Very, very slowly, and I think what needs to be realized is most all of these cases were filed, but there were no cases filed until 2022.
Mm-hmm.
It's hard, when you think back, your mind plays tricks on you about time, but there were 2 cases filed in 2022. There were about 19 cases filed in between, 2023 and 2024. And there are more being filed this year. So this is typical. This is the lagging bulge, that's going to occur in the development of the cases. There's lots of procedural issues in these cases. There have been no rulings, no adverse rulings saying that this type of lawsuit, this type of legal theory, which is basically a straight, medical, at least it's based on a straight medical negligence claim, even if it's fraud or something else. There's been no ruling saying, no, this isn't viable. There's been no court ruling tossing out the cases or any case saying that, no, the doctors are complying with the standard of care because they comply with, they say they complied with WPATH, even though most of them didn't do that either. At least that's the allegation in the lawsuits, right?
Right.
So there's been no negative ruling that's hurting the litigation, that's throwing any theory out on medical negligence. And we've got 2 cases that have progressed further, and that's, you mentioned the North Carolina case. Of course, that's Prisha Mosley's case, which is down to medical fraud. She had medical negligence cases dismissed, not on the merits, but because the statute of limitations barred their recovery too long in past, which is the issue when you look at most of these cases. I've vetted several of these cases, and the problem is, on most of them, frankly, is that the medical negligence cases, it's been too long, right? It's too long to bring a lawsuit. It's been more than 2 or 3 years. The other case, just real quick, that's progressed close to, if not equal to, Prisha Mosley's case is the Oregon case, Camille Keifel's case, right? Mm-hmm. That actually survived dispositive motions such that the statute of limitations motions were granted, dismissing a lot of the claims as being time barred, as I just mentioned. There were a couple of other novel theories that were dismissed. One of them was treatment of a person under disability, mistreatment of a person under disability. I'm sure I'm not naming the statute exactly correct. The court dismissed that. That might go up on appeal, but that's not a straight medical negligence claim, Right. And the medical negligence claim has advanced against basically the psychological center, LCSW, that approved, gave the okay for the surgery to proceed. So that the statute of limitations was not barred on that. There were a lot of motions to dismiss filed on it, and it survived all of those. So that's going to go ahead and proceed on the medical negligence claims against the LCSW and or the organization, the counseling center she worked for.
Right, Kevin, thank you. Also, I just want to point out there's another, in addition to the statute of limitations, there's something else, and it's not in every state across the country. It's called the statute of repose. And it's a law that bars legal claims after a certain period has passed from a specific event, even if the injury hasn't yet occurred. So it's very different from the statute of limitations, which begins to run after the injury or the damage occurs. In Prisha Mosley's case, because I actually did attend the hearing on the motions to dismiss, and that was a whole other thing. But ultimately, Judge Irvin, who's the judge on the case, and by the way, he's the grandson of Senator Sam Ervin of Watergate fame. But ultimately, he had to rule the statute of repose in North Carolina is 4 years. So no matter what, the statute of limitations just didn't come into play because the statute of repose just shut the whole thing down 4 years after her surgeries or treatments occurred. So that can be problematic too. What was very impressive, however, was how the attorneys were able to tee this case up as a fraud conspiracy to commit fraud. And not every state would allow that type of claim to proceed. And it was allowed to proceed in North Carolina, which is why this case is extremely important as it's winding its way through the court.
Okay, we'll come back to Precious' case and that fraud strategy. So I want to go back to the idea that these are all moving kind of slowly. They're plotting through the legal system as expected. Is this pace slow because this is a new realm, or is this? Would it not matter if this was kind of a new world of lawsuits?
Well, this is Kevin again.
Yeah.
I don't think it's because it's new. I mean, when we say it's new, this tort, this count, this lawsuit of medical negligence or basically fraud that is not revealing to you all the risks before we received the medical care and we knew or should have known, about those risks. Those theories have been around that's Blackstone hundreds of years. So it's the same theory. The only thing new is the facts, right? Instead of it being a lobotomy or an ovurectomy or something of that sort, which shouldn't be done, now I don't know why it's always women, but now it's this primarily, at least. Now it's, this kind of gender affirming care, to call it something kind. So you're applying the facts to classic tort law, and there's nothing, I don't believe, that has slowed the cases down that we just spoke about, besides the typical wear and grind in the court system. There's always procedural motions that take place. First, for example, on the statute of limitations. So somebody filed a lawsuit, for example, in North Carolina, but this has happened in a lot of the jurisdictions. Some of the counts are arguably time barred, some aren't, right? And that takes months to get those motions heard and briefed and argued and get on the court's docket, and it takes months to get a ruling, and there might be an appeal of those rulings. And then you have to determine which counts, remain that the court has not dismissed. And there's a lot of development that has to happen. It's not so clear cut that whether or not the counts are dismissed time barred, because there's different evidentiary rules in each state, each jurisdiction, on when the statute of limitations should accrue. In other words, it just doesn't accrue at the date of the surgery. In other words, it's not just you can't sue for 2 years after the date of the surgery, for example. It could be 2 years after the course of treatment or care ended following the surgery, which only makes common sense, right? The same doctor's treating you, and they treat you for another year, and they tell you everything's okay when it's not, and then you finally get away from that doctor, and you say, oh my gosh, I've been mutilated, or I've suffered all these horrible consequences. So some states have rules on that. So you have to go through and take depositions and discovery and argue when the course of treatments, ended, or in Oregon, when you should have realized that a cause of action existed. They've all got this different language in there. So I think this mainly the typical grind. There might be, because it's a little novel and there's a little more writing on it, it might be the courts are being more careful, right? And things are taking a little longer.
Yeah, that's for sure.
And does it matter if some of these plaintiffs are minors?
For the statute of limitations, or for the delay in the proceeding?
For the statute of limitations, sorry.
Yeah, do you want to? Yes,
it does. It does.
So,
and there will be periods, from the age of 18 on, they have so many years to bring the lawsuit, right, Kevin?
That's right. So usually you've got a 2 or 3 year statute of limitations in most jurisdictions in which you would have to bring your lawsuit after you reach majority,
Mm-hmm.
right? So after you turn 18. So if you had the surgery at 16, which is true of a lot of these, at least about half of these cases,
Yeah.
let's say, or they had the surgery, or they had, um, the cross-sex hormone or the puberty blockers as, in their, like, say, 15, 16, 17. Then they realize they got 2 years from the time they turn 18 to bring the lawsuit, but they don't realize that they don't start to detransition until they're 21 or 22. So, and the other issue is that's very complicating that was already raised is the statute of repose. So a lot of states have an internal statute of repose. So let's say the kid's 11 when they get the care, right? The care they shouldn't have received, and so usually they would have until they're, they have about 10 years, right? 9 years to file a lawsuit.
Mm-hmm.
They have 2 years after turning 18. But a lot of states have an internal statute of repose, which is just, it sounds fancy, but it's just an internal time by which you cannot file a lawsuit, even if, no matter what, even if statute of limitation is told or paused because you're a minor, because you become mentally incompetent or some other reason, you still can't file a lawsuit after 5 years. So this 11-year-old can't file a lawsuit after they turn 16, if
Yep.
that's when they receive the care. So there's other bars to recovery and complicating factors. Yeah.
Okay.
And I'll add to that too. There's a movement across the nation. Certain states are actually enacting laws that are expanding the statute of limitations specifically for folks who regret their transition. I haven't seen the interplay yet between that and the statute of repose. I've got to believe that when these um, bills are presented, that hopefully somebody with a brain realizes that if there is a statute of repose, that there needs to be a carve out, that the statute of repose cannot apply to that particular bucket of cases.
How likely do you think that um, those bills are passed? Because I have seen them in some states.
It's starting. Off the top of my head, I can't recall. I think South Carolina has done it, and maybe North Carolina. I'm not sure, but it's starting. There is a movement afoot to do that. States are starting to recognize. Another thing that just happened today, boys and girls, is actually over the weekend, but it was finalized today in Texas. Not statute of limitations, but insurance. Because we started out very early on, Kevin and I, talking about our work with insurance companies. And so now in Texas, it will be the law that if an insurance company pays for the surgeries and therapies on the front end, okay, if a person has regret, they have coverage on the back end. Because today, many of these detransitioners can't get the therapies they need to alleviate their symptoms. Their, the therapies that they need to recover from the trauma. So that's breaking news today out of Texas.
Yeah, we're going to come back to that bill a little bit later because that's obviously significant. And my question about statute of limitations, these regulations, if a state does pass a carve out for detransition, say, is that retroactive? So somebody who filed a lawsuit and it got tossed because of statute of limitations, could they refile?
It depends on how the law is written. Most statutes are not retroactive unless specifically provided for. Am I missing something, Kevin?
No, it's a good question. They're called ex post facto laws. You generally can't change if the statute's already run, but other tort reform has done that. Other tort reform, as even if your cause of action is run, it's too late. They've put 20 years statute of limitations on certain, like asbestos and some
Mm-hmm.
litigation and such. So I do think it's possible. I think your question was a little more interesting, and that is, what if the case is already dismissed? If some of the counts are already dismissed on statute of limitations grounds for some of these people that were early bringers of lawsuits. I don't know what would happen there. I would assume they still have a good argument to bring a new lawsuit, even if it was dismissed, because it's been opened back up. the period of statute of limitations has been opened up, and this is a main push. I do think this is coming. I mean, you think about 27 states are now kind of banning or restricting the care in some way. So I think these same states are going to end up extending statute of limitations. And gosh knows President Trump has talked about signing an executive order to do, although I don't know that that's the way to do it.
Yeah.
That would be effective. But I do think it's coming. I think, in fact, that's the biggest thing you can do that any legislature can do right now is to extend the statute of limitations for these persons who were vulnerable and didn't realize for a while, and then have determined that they need to bring a lawsuit, and it's too late, because that is the main hurdle for most of them, for sure.
So, and this comes up with other issues like around the EOs and other federal legislation efforts. Could there be a federal expansion of statute of limitations, or less limitations on a federal level that would affect the states, or do the states override federal?
It's pretty much the states. It's not that they override so much, but you can say that it's that the states have their own causes of action that are torts. They have their own common law and statutory law by which you can sue somebody to get money damages. There really is no federal tort law. You have federal procedural law, and then you have statutory creatures. You can sue, for example, under, as was done with Shapeshifter, with ACA, with the theory under the ACA.
Right.
But even the Federal Torts Claim Act requires you to have an existing state tort that you sue, right? You bring the suit by. But it gets a little complicated because federal statutes can create duties, right? Can create duties that, if violated, create the ability to bring a tort or a lawsuit for somebody based on what they call a per se violation of a statute. That the statute itself creates a duty, and when let's say the doctor violated that duty, it gives rise to the lawsuit. But by and by, I think that the short answer is these would have to happen state by state. For example, President Trump signing an order, I don't think does a lot for many of the cases that are potential cases that are out there. It doesn't override the state's own statute of limitations.
I agree. Yep.
Got it. So, ultimately doctors in some states are protected. Doctors in other states aren't protected, which means probably that doctors who want to do this are going to migrate to the blue states.
Yeah.
Instead of there.
Right. I mean, you could create, I know maybe we're getting too much of a detour. The federal government could, by law, they could create a statutory cause of action, a federal cause of action, similar to a civil rights cause of action, right? But that would have to be legislation, and they could put an unlimited statute of limitation or 20-year statute of limitation on it.
Wow.
I'm assuming it would be difficult to pass. I'm pretty controversial.
Well,
but,
right now, maybe not eventually.
Yeah.
So I want to go back to the fraud argument for Patricia Mosley. Let's go back there now. So can you encapsulate, like, what is that argument that's being applied?
Sure. The essence of that argument is that, they had an obviously mentally distressed woman, a young girl, I should say, a teenager, and they represented to her that if she underwent the course of treatment, which involved the Corsex hormones and subsequently the mastectomy of her very healthy breast, that would alleviate all of her mental symptoms. And, fraud is, you made representation that is not true. You made it so that the other party relied upon it. You intended for them to rely upon it, and they reasonably relied upon it to their detriment. And so that's the gravamen of that allegation. And because it was adequately pleaded in the complaint, it was allowed to proceed. And then tacked onto that was the conspiracy to commit fraud. So you endocrinologist, you plastic surgeon, you therapist, you all conspired together to convince this distressed teenager that she needed to do all this in order to overcome her mental conditions. And you knew that this was not true. And she relied upon it, reasonably relied upon it, to her detriment. So that's how the case is proceeding.
That seems like a high bar. I mean, you have to prove intent. I mean, clearly some of these clinicians are kind of nutty true believers. And so does that excuse your, is it still fraud if you believe in something crazy?
So let's suppose, that's a great question. Let's suppose that one of these practitioners, before giving advice to this teenager, did a little research and saw that there actually wasn't an evidence-based basis for giving this medical advice. And in addition to that, this practitioner actually saw that there were people who had regret. Okay? That's the kind of thing that I think a court would take a look at. And that's so when we are in a lawsuit, we engage in what's called discovery. All right. So I'll show you mine, you show me yours. Let's see what we have here. And so all the plaintiff has to do is plead that to overcome the hurdle, adequately plead it. And now, now they take it to the mat. What can they find out from the other side? And so it remains to be seen. But you're right, it does seem like a high bar. Fraud is very, very hard to prove. It's got, depending upon what state you're in, 3 to 5 to 6 different elements. But the breakdown is you make a false representation of a material fact. You know it's not true. You intend to induce the other party to rely upon it. They justifiably relied upon it, and now they're damaged. So, and it's not much different than some of the other cases that we're seeing, but this is the one in North Carolina has moved along.
What about the expectation that, and that maybe it wasn't knowingly committed fraud, but that you're an expert, you're giving this care, you should be on top of the most credible evidence, but you weren't. How does that come into play?
Well, that's malpractice, right? Well, is there a standard of care? Which there's not. That's a good question, and I think it depends upon how the plaintiff's lawyer approaches it and how the defense defends that. What do you think, Kevin?
Yeah, I mean, you're asking, I think what you're getting at is there a specific intent element, like I intend to defraud you.
Yeah, that's
and different states have different rules on that. It can get pretty subtle because, as you can imagine, it can turn into a pretty ridiculous burden of proof on a poor plaintiff to actually determine what's in somebody's head. You can prove. Nobody says, "Hey, unless you're watching 2020 tonight or something. Hey, I intended with malintent to murder my wife, as opposed to, I just got upset with her and hit her with an axe across the table." Its intent is very hard to prove. You prove it by what you call badges of intent. Some people call it that. Indicia of intent.
Yeah.
You'd call it's evidence that is not specifically direct to the intent item. It's stuff like was just being recounted. It's stuff like, well, you knew that there were no studies that supported that this type of surgery or engaging in this type of medical course has any proof of helping the person long term, right? You know that it doesn't help suicidality. You realize that, right? You could Google it in 1 minute and find out, or 5 minutes. You're a medical doctor. I'm trusting you. So the medical doctor might say, well, I was just going along with what I thought the standard of care was. Well, then the question is, yeah, but don't you have a duty to look behind that some? At what point does that become fraud? See, there's a continuum there. It's not as clear cut as it sounds.
Right.
There's a continuum there of at some point the jury is allowed to conclude that you were so caught up in the ideology that you didn't care that there wasn't sufficient evidence there, right? You just thought you were doing the hippest, coolest thing that WPATH supports, even though it's just a private organization. I don't know how that can ever establish a standard of care. So, and the lobbying organization, special interest group at that, without getting into all that. So how can you really believe that? You had to know that this was a false ideological movement, right? I mean, why are you doing this? And so if there's no evidence to support it, and you're doing such a drastic surgery on somebody that can cause so much harm, and let's say you're lying, I don't know, I don't know each case specifically, but let's say you're lying to the parent that you're going to save their life, dead daughter, live son type of misrepresentation. Well, at that point in time, you're pretty far down the continuum as of a jury being allowed to conclude that you in fact committed fraud on this person.
The other, part that seems, if you are a clinician and you promote this garbage and you call yourself an expert just by merit of your position, but you are not looking at the evidence critically, are you an expert? Like, can you call yourself an expert? Because that's what people are going to care about. I mean, that's equally fraud.
Yeah, have you lied by omission? I think, which is what the complaint alleges, right? So the complaint, pretty sure most of the complaint goes into all of the misrepresentations by omission, by not telling me this or that, by holding yourself out as an expert in the field when you're not, and by presumably holding yourself out that you knew what the evidence was behind the recommendation, the medical diagnosis and prognosis that you in the prescription that you're giving. That's what we all assume, right? So it goes beyond. It's certainly harder to prove than a straight medical negligence case, which is time barred. So, but the fraud claim is not, and it is the facts here are so extreme in a lot of these cases, not just Prisha Mosley's, right? That it does at some point begin to sound in fraud.
Right.
So, let's talk a little bit about Chloe Cole's case, because she's kind of the big, most famous, if you want to call that, detransitioner. That case seems to have been going on the long, and she's suing Kaiser, and but we haven't heard much about what's happening there. Can you bring us up to speed on Chloe Cole's case and just go over the basics of it and where we're at?
I cannot. I don't know, Kevin, if you have any. Because Themis
Right.
is not funding that case, so I
Themis didn't involved with that one. No. Well,
no.
Chloe Cole's case was going forward with Chuck Lamondre's firm in California, right? Who has a few other lawsuits against Kaiser Permanente, and then it was also with what's her name that went to the government, right? Went to
Harmeet Dillon.
Yeah, Harmeet Dillon's firm and Center for Justice or whatever that's called, American Center for Justice or some such, had brought that lawsuit. So Harmeet left after initially filing the case co-counseling with Chuck Lamondre's firm. I have talked to Chuck several times and regularly about the status of his cases. Generally, because he's in California and Kaiser has arbitration provisions in its treatment agreements that have been upheld in California, although there's a way around them sometimes. Sometimes they're not enforceable. Arbitration agreements are not enforceable for medical care in some instances in California. I'm not an expert in California law. They've been caught up in the procedural motions to dismiss and motions to compel arbitration. So defendants, hospital systems, always want to compel arbitration. Right? They do not want the plaintiff to get in front of a jury. They don't want you, a very good plaintiff's lawyer like Chuck is, arguing to a jury how Chloe has been harmed, and Chloe presenting her case to a jury, because obviously it's very compelling and emotional. They want an arbitration panel that's going to just, decide on some briefs or some submissions of, deposition transcripts or something, how much should be given. So that's why Kaiser has moved to compel arbitration. And my understanding is it is just still caught up in the tangle of, will arbitration be compelled? What counts will survive? So it's waiting to progress. And once a ruling is made on that, then further discovery can be had in whatever format you're going to be, whether it's arbitration or the court, the actual private court.
Yeah,
Right.
I'm
private
sure
litigation.
is brutal.
Yeah.
They're formidable and fighting with everything they have, because I think that case will be devastating.
Obviously, a huge medical care system like that is aggressively advertised for this type of care does not want this to get to a jury or proceed to a jury and get past the various evidentiary phases and rulings. It would prefer that it remain in, the litigation, so to speak, remain in arbitration. And so, yeah, they're fighting tooth and nail for it. Absolutely. Nursing homes do the same thing. If you have a parent in a nursing home, a lot of them have arbitration agreements that if they commit malpractice against your parent, that you cannot pursue them. That has at various times been declared illegal versus legal by different legislatures, different states, different courts. That varies jurisdiction to jurisdiction.
Right.
Okay, let's keep going. Let's talk a little bit about Clementine Breen, who's suing, perhaps the most prolific practitioner of gender medicine, that's Joanna Olson Kennedy, for quickly affirming her gender dysphoria and prescribing interventions. So how far along is that case? Can we talk? I know that's a new case. Can we talk about that at all? It was noted in The Economist. It's no small thing either.
No, I'll defer to Kevin, but I was, I happened to see Billboard Chris live when she approached him to tell him what she had been through. I mean, it was like a gift. And so I have to imagine that maybe Kevin, does she have the same issues with the arbitration provisions, or how is this
Yeah,
going to? Yeah.
yes, and I think before the arbitration provision, there are some preliminary motions to dismiss some of the counts, and then a motion. I believe there's a motion to compel arbitration. I don't know what I don't know is what the dance is in California. If you go through the motions to dismiss on the counts, the dispositive motions, or that the defense files to kind of pare down the counts in the complaint
Right.
before there's a motion to compel arbitration or not. I assume that's the way it works because the form of the counts probably determine whether it should be an arbitration or not, but I'm not certain because, again, I'm not a California lawyer.
And
But
it's brand new. It was only a couple of
know
months old. So
it's a brand new suit. It was filed, late last year. And I know there's a series of hearings and motions being argued either this week or next week by the Jordan Campbell firm. I know it's I don't know if they're being argued this week or next week, but but that doesn't mean you'll have news for several months. You might not have a ruling on that for months and months and months, which is what's supposed to be.
Right.
And if that case goes to trial, let's say it does go to trial, will a jury be influenced or allowed to be influenced by the bad publicity that Joanna Olson has gotten for suppressing research results that, appear, makes the most sense that they're not favorable to her?
Well, picking a jury is going to be difficult, right? They're going to ask questions. Are you familiar with this case? Have you been following other detransitioner cases? What do you know? Do you have a detransitioner in your family? Do you have a transitioner in your family? I mean, it's a really complex. It could take weeks to put a jury together for that.
And could they ask about that? Is that
absolutely
relevant? Okay. So,
absolutely. Yeah.
Yeah, it's going to be really tough to find. Well, maybe not. Maybe our weird bubble that knows about these things probably.
So I did get a little bit of a brief update from Charles Lamondre's firm on on Chloe Cole's case. Sorry, I'm shifting gears here. And so that's correct. Chloe Cole won the first round. Such an arbitration would not be compelled, and then the healthcare system appealed that decision. So it's on appeal. It's been expedited for appeal. It's been briefed, but it's the trial court case has stayed pending the court's decision on that.
What that it's been briefed? What does that mean specifically?
That means that all the arguments, memorandum and support have been made as to why the case should be in arbitration or not in arbitration, depending on which side you're taking. So initially, Chloe Cole won the first round on that, right? She won it should not be an arbitration. It gets to proceed as a normal lawsuit would in front of a jury, your right to a jury trial, constitutional right to a jury trial. But that has been appealed. And so then both sides file authorities and lists and arguments, 15, 20-page briefs citing dozens and dozens of cases. It takes a long time to write them, and then the court reads them and usually has hearings on it. And, it takes a long time. And
that, I'd like to get into the kind of Kaiser attorney. I mean, I don't really want to be in that mindset, but is it kind of, do they anticipate, oh yeah, she's going to win this one, but we're going to appeal and we'll get the appeal? And I mean, is that kind of just kind of standard stuff, or are they is it enough to make them nervous?
Yeah, I don't think there's anything nefarious in, maybe it's because I'm a defense lawyer, in the intent of the defense lawyer for the healthcare system in trying to enforce their rights and, filing for appeals and determining whether the arbitration clause should apply. But certainly the reason that they're doing that is because they don't want to be in front of a jury. We know that. Or they would agree to be in front of a jury. And if they wanted to have a trial a year ago in front of a jury, they would have had a trial a year ago in front of a jury.
Exactly.
So we know they don't want that, right? Because that's what Chuck wanted, right? That's what Chloe Cole wants.
So the first, sorry to nitpick about this minutia, but so the first appeal for it to go to arbitration, wouldn't they have presented their strongest case? Like, what do they have left? Or does it go to a completely separate process or separate people or different judge? Or
a different court. Yeah, it's a different, instead of one single trial judge ruling on it, it goes in front of a panel. Again, I'm not a California lawyer, but typically it's a panel of appellate lawyers. It could be typically something like 3 judges.
Yes.
And they have their own clerks and staff that do more legal research. So it could just be the disagreement on a legal point.
And so, I mean, is it kind of an odds game? Like, oh, if we roll the dice again, maybe these folks will be more sympathetic to poor Kaiser's cause.
Yeah, there's a big, go ahead, Kevin. I'm sorry, but arbitration.
Go ahead.
Arbitration is like the Wild West. Okay, it's not where depending upon what kind of case you have, it's not the most desirable forum to be in, and so the rules of evidence are loosely applied. But if you have an adverse ruling against you in the first round in arbitration, you almost have no right of appeal because the standards of appeal are completely different than the standards of appeal in a courtroom. And so it's the Wild West. It really is.
So you're saying arbitration isn't ideal either?
No. Kevin, you can contradict me here, but
yeah, it's more ideal for a defense lawyer because they don't in an emotional case, in a personal injury case, because what you fear is the jury. You fear the possibility that the jury could give an anomaly, or what you call, people call it runaway verdict, right? So a jury could give a runaway verdict. A jury could be overcome by emotion and facts. That's the defense lawyer frame of mind, by the way. The plaintiff lawyer would say, well, I'm entitled to a jury. A jury's allowed to hear all the facts. So it's more It's certainly true that when you have an arbitration and both sides kind of move and strike through possible arbitrators, there's a lot of randomness on what result you're going to get. That's usually more in a commercial case where there's nothing emotional at issue. If there's emotion, if there's death, personal injury, tears, real tragedy involved, then generally speaking, a defense does not want a jury. They would prefer to have somebody a little more unimpassioned ruling on it, like a court. They would prefer a bench trial, frankly. They want a judge to, depending on the judge, to sit on the case and give a decision on how much, or whether you proved your case up and how much the compensation should be. So, the arbitration vehicle exists to minimize exposure to the healthcare system. That's why the healthcare systems want arbitration clauses in in that jurisdiction to limit their exposure, to limit how much they can get hit for with a jury verdict. It's tort reform. It's the way they limit their exposure. So generally speaking, they want them.
And I would follow that point. So let's say that it goes to trial. Plaintiff, Chloe Cole wins. I don't know, win is the right word for that. But that decision, is it still every case plods through the same, or do the cases build on other cases? Is it just, big, is it just a big light in the sky that says, come on, these cases could win? Or is there, does it have a bigger impact than that?
Well, I certainly think what you're getting at is will there be a dam burst, and what will bring that about, right? What will be the causative agent? Would a big plaintiff's verdict, right, a big verdict by Chloe Cole in a civil lawsuit against a healthcare system in California, will that help other courts, to recognize this type of thing? And I think the answer is yes. It's not precedent in the sense that, hey, I'm quoting Chloe Cole's case to a North Carolina judge. It's not precedential as in they have to follow it. Stare decisis, you got to follow the law of the case. But decisions could be reached in Chloe Cole's case at the appellate court, for example, on the appellate issue, right, that are determinative and guiding for other courts in California. So all of them are a little bit of a brick in the wall that helps build your case. It's hard to say unless I have a specific example. But if there's a big issue of law about, for example, whether the doctor's actions equate to fraud, if they just had no basis to be given this advice at all, and we're caught up in the ideology, well, certainly a couple of jury decisions that are upheld on appeal, right, would be persuasive to other judges in other jurisdictions, even if they don't specifically have to follow, they're not bound to follow that case. Really, you're only bound to follow cases that are the presidential value, that are superior courts to yours, appellate courts to you as judge in your own jurisdiction, right? California judges are supposed to follow appellate courts and decisions of California judges and courts, not other jurisdictions. But you can argue them. You can say, California doesn't have a case on point. This is a case of first impression. Kathleen's seen that a million times, I'm sure. This is a case of first impression. And so we're going to give you a little survey of other jurisdictions and how they've handled this question that help our case.
Right.
Okay, so it's not exactly setting precedent that they will refer to, but an attorney could use it as kind of guidance, propose it as guidance, I guess.
Absolutely. And the reverse is true. If there's a decision throwing out a fraud case in a med mount, in one of these cases, and there might be, there's going to be some losses in these cases. I've always said that. The ground is going to be littered with some bones here. It's a battlefield. But if there's some losses, then the defendants are going to bring them up. They're going to say, hey, this court threw this out, Judge, you should throw it out. And the court might say, yeah, but they have different, it's a different state. There's different facts. There's a different standard for the fraud. There's a different standard for, the element of knowledge and intent. So I do not find it persuasive. I'm not following it. But they still use it if they think it would help them.
Got it. Okay, let's shift, no pun intended, to Shapeshifters case. And we have an update that we can talk about. Maybe give us the background on that case, what the case is about, what his situation is, and what status we have. Kathleen, I think you're the...
Sure. So, unlike the other cases, mostly for the women, this takes a completely different tact, and it takes the anti-discrimination provisions of the Affordable Care Act, specifically Section 1557, which says thou shalt not discriminate against somebody based upon their sexual orientation. And it boils down to a civil rights claim. And so what it essentially claims is that this young man was a gay man with extreme internalized homophobia who presented at Fenway Health, which is a federally funded clinic. And instead of addressing his issues and trying to get to the heart of why he was so uncomfortable, they discriminated against him by disregarding his sexual orientation and transed away the gay. And so, and this man went through the ultimate of surgeries, only to wake up. And I remember some of you might have been there when he came out on YouTube saying, "I'm a woman. I mean, I'm not a woman. I'm a gay man." And I think it was like 2 or 3 years ago on YouTube, and it was really hard to watch. Now, that's the first case that was filed in the nation like that. There's another one in Southern District of New York. However, that case, some may crow and think they're popping open a bottle of champagne because the district court, the federal district court, dismissed the claim. But the decision is really about a novel and highly technical point of law and completely unrelated to the substance or the facts. So the judge did not say, nope, you don't have a claim. And it also has technical deficiencies because the plaintiff's arguments on the motion to dismiss were not even addressed in the opinion. Not at all. So the case is on appeal. So as my mama used to say, the jury's still out on this one. So the case is on appeal. It's not substantive. It's not saying that Shapeshifter does not have a cause of action. And I read maybe half the opinion. It's a lengthy opinion. It's a nonsensical opinion, and so it remains to be seen. And then we have this other case that's in the Southern District. I can't remember the capture right off the top of my head, but that will pursue the same cause of action. And it's interesting because in the New York case, the defense said to the federal judge there, well, hey, we have this case in Massachusetts. Why don't you wait until you see what happens there? And the federal judge, and the Southern District of New York is the oldest federal court in the country. The judge said, excuse me, I think I can think for myself. I don't need to wait for another judge to tell me what to do. So we're waiting to see how that will turn out.
Yeah, and even just expanding on that just a little bit, the court really didn't dismiss, it did not dismiss the claim. It substituted Correct. In the United States government as, again, it is hyper technical under the ACA. She sued a private clinic that was receiving a certain percentage of federal funds that allowed right. them to be sued under the ACA for civil right. rights issues. The motion was made by the government to dismiss. By the clinic to dismiss. The federal judge took the odd step of, instead of ruling on the motion to dismiss, said, well, I think the federal government, the U.S. government, should be the defendant since they're the ones funding this. So I'm going right. to substitute them in as the party. So it didn't rule on the merit. There's been no ruling on the actual merits, of the claim. It's a procedural issue. We'll have to see where it goes. It's going to be appealed, but it's not. Just to be clear, that's not a straight medical malpractice action. It is you have discriminated against me as a gay person under the ACA because you received federal funds. It's a unique theory. I'll say unique. It's certainly one of first impression. So
It's essentially a civil rights. It's a civil
yeah,
rights
it's still
claim.
civil rights. So I wouldn't be surprised that this went up and down several times. Right? It's going to be grappled with.
Yep,
And,
I agree.
okay, I have some questions about it. So in switching to, the ACA or the U.S. government rather than this provider, does that basically remove any liability for that for Fenway's provider?
Yes.
Oof.
Right.
Well, that's
Government steps
Yeah,
in.
that's why it de facto, that's why it was shorthand to say they got dismissed. They got dismissed as then another party was substituted in for them. It's not the typical dismissal of your claim has no merit and we dismiss it. That's the typical motion to dismiss, right? Or it's legally deficient under the law or whatever. This one was you have the wrong party in our opinion. You don't get to choose your party, which is going to be part of the appeal. I'm going to determine as a judge that it should have been the federal government instead of, well, wait a minute, I get a right to determine who I'm suing as the plaintiff. I have a right to choose my cause of action and my party defendant, So, yeah, that effectively lets that clinic off the hook. Absolutely.
But okay, so now, a year ago when the Biden administration would have been the U.S. government, now we have the Trump administration. Does that change? I mean, does the Trump administration then have to argue against Shapeshifter? How does that? I don't know what that means by suing the U.S. government in this case.
That's an excellent question, and I asked that right out of the box. And Kevin, I don't know if you have the answer to that, but I think once they're substituted in, it takes away the civil rights aspect of the case. They've been forced to defend, but under a different theory, thereby converting it into almost a medical malpractice kind of case. Am I getting this right, Kevin?
Yeah, Federal Torts Claim Act. Yeah.
Yeah.
Well, that's a radically different case.
It's a different case, and it's a different case, and it's not the point that was trying to be made that it's a discrimination case, right?
Mm-hmm.
So the answer is, I mean, when you say is the clinic off the hook? Well, it's off the hook for the specific claim of discrimination. It's not off the hook of did it do wrong in its care and treatment of this person, right?
Mm-hmm.
So that's going to have to work its way through. But it certainly could be that the current DOJ, AG, whoever, I don't know all the way that works, determines that it's not motivated or its motivations are different than the Biden administration, that it's not going to defend this type of care. It could determine that. I don't have any insight on that, but based on statements that have been made, that's what it feels like to me. So I hope they jump in here somehow and try to give justice.
Right.
Okay, one side question about Shapeshifter's case. I mean, he presents extremely feminine, right? He wears lots of makeup. He's had lots of plastic surgery. He wears women's clothing. So if this went to trial, does that, or maybe even if it doesn't go to trial, does that complicate the issue? Does that have any impact? Could
It's a good question. I don't know. I don't think he can afford. Again, this goes back to Texas having this law. Insurance companies, pay on the front end, pay on the back end. I don't know that Shapeshifter can afford to do what needs to be done to undo the damage.
right?
Kevin?
It's more than just he is very very feminine. Is that it's so regressive? But could they say, well, he's wearing makeup, he's wearing very feminine clothing?
Well, he's doing that. He may be doing that in public, but you don't know what's going on.
Yeah.
when he's not in public.
Well, when I hear, let me just say this: when I hear questions like that, I really mean this. I don't think that's a lawyer question. I think that's the question that everybody should ask themselves. If I'm on the jury, right? Because
Yep.
I'm not a jury member. If I'm on the jury, how would that affect me, right? How would the person's presentation affect me? Would it prejudice me towards them, as in, well, I don't know what the harm, is it that simple? Or is it more, and I hope that this is the answer, is it more that this is a very authentic, caring person and they deserved better treatment? It's okay to be an effeminate gay, okay?
Right.
It doesn't mean I need surgery or, medications that permanently change my body and voice and all that. So I think that the case to be made is these are vulnerable, authentic people who deserve care and attention and justice for not receiving the proper care and treatment, regardless of how they present. But I think that issue that you raise is a good one because I think that's going to be present in a lot of these cases, right?
Mm-hmm.
Mm-hmm.
But I will say, and I'm sure you will agree, I am always very impressed when I get on calls or interview or talk to these people that have been damaged. A lot of these plaintiffs in these lawsuits and just plaintiffs in general, potential plaintiffs who you interview, who you think, is this guy going to, this guy or girl or whatever they're presenting as now, going to be just a, I hate to say it this way, but like a basket case or just
Mm-hmm.
weird. And you talk to them and it's like, oh my gosh, these are very mature people that
Yes.
have been through a ton in their lives. So much, and that shapes you as a person, obviously. So much stress and anxiety and hardship in dealing with maybe being a gay youth or presenting a different way. They really do present very impressive as a whole. And I actually see a constant thread with them, that they all have this kind of very mature, authentic thread when you meet them and talk to them. That seems to be whatever, regardless of whatever their other personality variations are. They really do seem to have that. Which is interesting to me. Have you all seen the same type thing?
Yes, absolutely. Every single one I've spoken to.
Very well spoken, very calm, very reasoned. When they talk through it, it's interesting to me.
Yeah, I have. Well, let's wait, and then we'll talk about the ones that don't go so well. So, are there any on the rise, any on the horizon, or any that we're missing, and kind of that we can talk about out of those 20?
No, well, I will say that several of these cases, some of these cases are being discussed. The discussions are ongoing for potential resolution in some of the cases.
Right.
That is going on. So there is interest in settling some of these cases by the other side. I can't speak to how much or anything like that, but that's a good sign. And also, I believe that the Love Doll case is going to be arbitrated soon. I don't know if it's over the summer, and that's against Kaiser in California, right? Is that California? I'm not sure it's in California.
Can you just
Um,
give us a rundown of what that case is? Who's
that's the same group. I don't know that one as well because I haven't dealt with it. But that was Harmeet Dillon and that's
okay?
Charles Lamondre. I don't know. For example, when you ask me, do I know about? I don't know age of intervention
Okay.
or exactly the type of surgery. I know that it's been an ongoing lawsuit. The Kayla Lovedoll versus Kaiser. It was filed in
Oh yeah. Mm-hmm.
2023,
Mm-hmm.
and arbitration was compelled in that case, and meaning it was granted by the court that it's going to be arbitrated instead of there being a jury trial, and so there is an arbitration coming up on that. I think it's in the summer. I'm not certain. So that might be the first kind of result. We have not a jury trial result, but an arbitrated result, and those are typically some details of those are published. Not everything about the result is published. There's a blurb. There's a reporting requirement on the arbitration results in California. Again, I'm not a California lawyer.
Right. I also
So-
want to report just there on May 8th, I think it was, or May 9th, we do have that case up in the federal court in Rhode Island. Hannah Eulery, I hope I'm not screwing up her name, But this was a very significant case because it was filed against Jason Rafferty, the doctor, who wrote the guidelines for the American Academy of Pediatrics back in 2018. And it was also filed against Michelle Fortier, the one who asked if chickens cry and Matt Welch's, what is a woman? But the parties voluntarily dismissed Dr. Fortier because of the statute of limitations. So this goes back to what we talked to over an hour ago about how the statute of limitations is just hamstringing these cases and allowing these doctors to get away with Lord knows what. So that's a very recent development that I thought I'd call to your attention, just to let you know how difficult it is for these cases, to get across the finish line, to get to trial. And that's why it's so important for states to enact extended statute of limitations.
So
It looks like Lovedoll was permanent puberty blockers, testosterone at age 12, double mastectomy within 6 months at age 13.
Good Lord, that's younger than Clementine Breen. She was 14, I think. My God.
yeah, that is messed.
That's what the let me attribute that. That's the California. That's a blurb by the California Family Council. I'm not reading the actual opinion.
Okay.
I'm just trying to get you a quick answer to your question. So
Let me ask. We talked about some defendants wanting to settle, and in the case of a settlement, well, even in arbitration, so could they say, well, we'll settle, or even arbitration, yes, this will go to arbitration, and whoever the Chloe Cole won, whatever that means in arbitration, could there be a clause of no where they can't disclose, a non-disclosure clause? So
yes,
Yep.
in both of those, in settlement and arbitration.
yeah. Well, not in the arbitration. If there's an arbitration decision, a lot of it is public. A blurb of it, what happened and stuff is public, but I don't know what details it gets. It hides some of the private stuff. I know that. If there's a decision, if there's a settlement at any point, right, where there's private litigation or arbitration, or there's no litigation yet, you can settle. You don't need to have a lawsuit pending to settle a case. So a potential case. Most of those are made confidential.
Okay.
Yeah.
Yeah, that's the agreement, and that's a requirement that most defendants put in their settlement offer and agreement. They don't want it to be public, or it can be publicized in a limited fashion. Sometimes it's you agree that you can say that you settled for an amount that was agreeable between the parties, but you don't say the specific amount, or you can give a range. It can be a whole continuum of things that you agree on, but the problem is a lot of the listeners and you might not know what, like the first several cases, settle for. There's already been a couple settlements out there. They're confidential.
Yep.
Yeah.
And I'm not discussing them.
Right. Yeah.
Neither am I.
Well, not only that, but I don't know what they settled for. I'm not entitled to know what they settled for.
Right.
And I just prefer not to go anywhere near it.
Yeah.
Out of respect for the lawyers and parties.
And I don't care to speculate.
Yeah. I don't want to, I don't want to get, I think us know about cases that settled that didn't go well. And I think some of it has to do with the fact that some of the people who are harmed are struggling, struggling before the lawsuits, we're struggling before the surgery, the interventions.
Yes.
This is a pretty vulnerable cohort.
Yeah, labile. They're very, their motivation and psychological state may wax and wane during the course of the litigation. Is really hard. You have to sit through several days, right, of deposition, getting asked every personal question possible about your behavior, about sexual stuff. It is harsh and hard, and I'm sure these plaintiffs lose. These claimants lose sleep and have incredible anxiety about it, and it's difficult to maintain. It is. And it's very, as you said, it's very expensive.
One of
Low
the,
six figures and
yes,
up to fund it, to pay for experts even, or hundreds of thousands of dollars to pay for
oh yeah,
experts.
just to get the case off, lift off is a six figure. One of the things that we at Themis are very concerned about before we decide to fund a lawsuit is, do we have a law firm that has the chops to do this? And what is the plaintiff, the putative plaintiff, um, healthy enough to withstand the rigors of a lawsuit? Because lawsuit is warfare. It's what it is. It disrupts your life for years. There may be 8 months where you don't hear from your attorney, and then boom, let the games begin, and the depositions are on, and you've got 4 days of depositions, and you have deposition preparation, and then you have to withstand the fact that the defense lawyers are clawing at you and trying to destroy you. They really are. They're trying to rip you down and make you afraid. And that's what warfare is all about. And so we at Themis try to be very careful and circumspect about what cases we're going to fund, because there are some detransitioners that just haven't really um, halfway recovered from what they've been through. And I've met many who are just amazing young adults. They recognize the trauma, they recognize what they've been through, and there are others that just could not withstand the rigors of litigation.
Yeah, I think it's hard to anticipate what that looks like for somebody who's not privy, who's not part of the legal world. Seems like you would just be able to tell your story, and then there'd be a jury that would go, "Oh yeah, this is terrible."
Right.
Are you talking about a trial? I mean, so they sit through a day or two or three of depositions. I mean, 8-hour days
Mm-hmm.
being asked questions, and by multiple lawyers. Because let's say you sue, a hospital and 3 doctors, they each get their own lawyer. And so you have 4 lawyers just going around asking questions, and the plaintiff's lawyer, your own lawyer, they can't really can't really do anything but sit there. It's not like on TV where you stand up and fight with people. They're allowed to ask almost any question they want. So there's not a lot of objection in a deposition. Let me put that one. It's not, you're not in court. A judge don't want to hear it.
Right.
So, and a judge isn't sitting there to begin with, so you have to bring it up to the judge later. So, then you go to court and you have to sit there for, let's say, 2 weeks and sit through it and sit through them saying everything about you, that you're not legitimate, you're just in it for the money, this is all about money, and you never should have, you're just having regret about changing, you knew all the risks, and your motives are attacked. Now, I'm not saying that every defense lawyer and every hospital, medical care provider will do that, but that's certainly what's a real possibility in a lot of these, and we know it's happened in a number of the existing cases that have gone through depositions, very harsh depositions.
Yes.
So the argument that you hear, you know, albeit it's on Twitter, but or X, is that this kind of buyer beware argument that oh, you knew what you were getting into, or you had the responsibility to research this. How applicable is that to these cases, and will that shut down a lawsuit? Is that enough to shut down a lawsuit?
No, that's an excellent question, because I witnessed that at the motion hearing for Prisha Mosley. It was an interesting thing. There had to be at least 10 lawyers on the defense side. The lead lawyer is actually someone I know, the only female on the all defense team. Okay. And when the men got up, they represented the different doctors, and they all, and I've never seen this happen before. I've never seen it get so personal, because Prisha was there, and she was about 7 months pregnant at the time. Every man got up and said to the judge, and then they pointed at Prisha. She did her research. She told us that this is what she wanted. She did this. She. Victim blaming on a grand scale. I've never seen anything
This
like
is
this.
you're talking about the public hearing that you
Yes,
attended,
it was a
right?
public
You're
hearing.
talking about
It
what
was
you
a
witnessed at the public hearing. Yeah,
I
this
witnessed
isn't
it,
in.
and that's I thought, well, this is a sneak preview of coming attractions. You know, that's I couldn't believe because I've been a defense lawyer. I would never turn around and point to my adversary and say, yeah, this was unusual for me to witness, and the judge I think took notice of it at the time.
So I want to go back to the cases that didn't go well. I mean, if you think about it, this is what's, the whole thing's disturbing, but what's exceptionally disturbing is that the folks who cannot withstand the rigors of a trial, going through the lawsuit and the trial and the depositions and all this stuff, those people are the ones who were preyed upon. Those, if anybody's vulnerable, it's somebody who is not even capable of getting through the beginning parts of a lawsuit. That
Right.
shows you who these doctors were treating. It
Hmm.
it's and it's frustrating because people should see what just how vulnerable some of these people were, and they did this anyway. They did the full surgery on males. They took the breasts off of young girls, young women. It's I just find it really infuriating that the system that really could help them, or at least provide them some resource to get more help, is not available to them because of their um, situation, of their vulnerabilities.
It's not a perfect system, and at the same time, plaintiffs' lawyers are not going to take cases that are going to fall off the tracks
Right.
because the plaintiff is incapable of withstanding the rigors of litigation. It's the reality
Yeah.
of being a plaintiff's lawyer, and it's sad. Um, to me, once we start getting verdicts that send the signal out, I think that's the goal. Is okay, and we know we're not going to win them all. We're going to have some losses. I mean, that's just reality. The odds are you don't win every case you bring. However, we are going to have some wins, and the wins are going to be big, and that will send a message out to the medical community. All right, take your chances. You want to counsel a kid to cut his penis off or remove a breast, knock yourself out? And then in those states where the statute of limitations has been extended, okay, take your chances.
Yeah.
And I think ultimately the goal is for it to have a chilling effect so that doctors need to think about this concept of do no harm.
Well, it's not just. You can also think of it as they're being educated. I mean, they're out there now. It's amazing. You talk to these doctors, and they're like, "Oh, I didn't know this stuff was going on. How in the world could you not know this stuff was going on?" It's
Right,
unbelievable to me.
right.
And then even when you depose the doctors, when you depose the doctors who are doing the care, and you ask them, well, what was your belief in the evidence supporting that this type of care would help? Really, that's always the big question, right? And the answers are so bad. It's like the lawsuits have many effects, right? Some of them are political, some of them are chilling effects, some of them inform the insurance companies, put their put their med mal rates up or stop offering coverage for this type of care, quote unquote.
Mm-hmm.
And some of it, a lot of it is let's educate the doctors. I mean, these are viable lawsuits. Nobody's bringing spurious lawsuits. These are viable lawsuits based on existing torts and causes of action that have existed forever. But it's also educating the medical community. Look how much these lawsuits have already educated the medical community about the fact that there is no evidence to support these. All the studies are low quality or non-existent. I mean, that's what everything coming out now says, right? So, or even that they're not doing even per WPATH's Soc 8, they're not doing a full evaluation, excluding other potential causes, for the care and treatment, and proceeding with a more conservative course first, which is what every doctor is always supposed to do with anything you go in for. So, right, give a differential diagnosis, choose the most conservative treatment of care that does no harm, and then try that first. So they're not even following that. So I think this is educating, educating the medical field, because God knows they weren't doing it themselves for whatever weird reason. They were just following along like lemmings, the group think, right? The zeitgeist that was out there in the medical community for what was hip and cool, and how do you look like you're the hippest, coolest medical doctor out there? I don't know what else it is, or it could have been. I really don't understand it. So that's what offended me about it. So still offends me.
Excellent point, Kevin. Also, for folks who are not familiar with the concept of medical malpractice insurance, medical malpractice insurance only covers negligent acts arising out of, the terms are sometimes medical incident or just the provision of medical care. When you take the claim outside the realm of medical malpractice and you focus on fraud or conspiracy to commit fraud or any kind of cause of action that is grounded in intentional conduct, you remove it outside the realm of medical malpractice insurance. And so doctors may be left defending themselves $1. And maybe the insurance company, because depending upon what state you're in, the laws are very different about what insurers have to defend or not defend or indemnify. You might get a defense until you get a verdict. And it could be done under something that's called a reservation of rights, where the insurer will continue to pay for your defense. However, if the verdict on the fraud or conspiracy to commit fraud is against you, Dr. X, we want you to reimburse us for the defense costs that we shelled out for you, and we're not paying for the judgment against you. So, if that doesn't make the doctors nervous, I don't know what will. Med-mal is one thing, they have coverage, that's fine. But when it's not med-mal and it's in this little bucket of intentional torts, I think once it hits doctors in the pockets, they may think twice before they undertake this course of care, so-called care, I should say.
Yeah, that could get pricey really quickly.
Oh, yeah.
Yeah, and it's a double hit, actually. It's a potential double hit. There's the potential that there's not insurance coverage for it, so you're personally exposed as a medical care provider, as a doctor. And then also, you might not get the benefit of the medical malpractice damage caps, because a lot of states have damage caps. California, by the way, has extreme damage caps. There's only so much money you can recover. So in Virginia, you can only recover, it's $2 million in a medical malpractice action. But if it's not under the med-mal, then there's no cap. There's no limit. The cap is a limit. You can get, 8 or 10 million and be personally exposed. So that should be convincing or persuasive to some people about providing this type of care.
That's good, because I know in South Carolina it's $350,000 for non-economic damages. I think it's either $250 or $350 in North Carolina. Yeah. So if you're not med-mal, sky's the limit.
Yeah. Now, not all those states will allow you to bring a fraud.
I know that's the problem. That's right.
Because most of them a lot of them will say that needs to be brought as a medical malpractice action. It's difficult to avoid it coming under outside of the medical malpractice tort. But the possibility exists, and different states have different rules and laws on it, obviously.
Boy, you would think that would be on their minds, as they're practicing, as these lawsuits get filed. It's hard for me to believe that this isn't a concern. So I want to just for a second get into the mind of the defendant's attorneys a little bit. Kevin, you've kind of been there in a different realm a bit. You're an attorney. You're Kaiser's attorney or Fenway's attorney, and you've got this person who has grievously harmed. It's clear that there's no real standard of care, but that this person was reckless, this clinician was reckless, and that harm was done. Do you just go, does it not affect you? You just do your job and defend this clinician, go home and go, yeah, well, God, that guy's just a monster, but then do your job. I mean, how do you do that job if you see that your client is deeply in the wrong, horrifically in the wrong?
The way I think you're supposed to do your job as a defense lawyer on something like that is to correctly advise your client. You just need to honestly evaluate and make recommendations as to what happened. You don't have to be the doctor's friend. I personally, on this issue, may have a very hard time. I don't know if I could do it, right? Everybody's got to make that own personal decision. I'm not saying that the lawyers presenting defenses for these doctors are bad people. I'm just saying for me, it'd be very hard to do. And I've certainly represented a lot of people, defendants, that have made mistakes that have cost, many lives and a lot of pain and suffering and injury. The way I try to handle that, I'm not saying I'm perfect every time. The way I try to handle it is honestly, is to tell my client, because I owe them that duty, right? They hired me to look at this case and tell them to evaluate it, not just to defend it, but to evaluate it. And they're going to ask me for an evaluation. And if I've got a bad case, I'm going to tell them it's a bad case. This doesn't look good. I don't like the way this is going to look in front of a jury. I don't like that, that they didn't know this or that. This feels reckless to me. I think the plaintiff presented as a very sympathetic person that the jury is going to identify with. This is a typical evaluation type that might happen, this language I'm giving you. And I think the damage range could be well in excess of what you're expecting here. I think you're thinking the case could be worth 500 to 800,000. I'm thinking it could be worth 5 to 8 million, and it could blow up on you worse. It's my duty to tell them that if I think it's that type of bad case. And that's what I think that's what these cases look like to me. That's what caught my attention. These look like cases that in front of the right jury could really result in huge verdicts. I really believe that, because I don't know what type of medical care you could compare this to in history. I don't get it. Think about it throughout the entire, not just like U.S. medical history. No, the entire world history. When has this ever happened? It's never happened.
So that
Nobody's ever started cutting off breasts and penises and, permanently stalling kids to have some little child's voice at 11 years old, like some bad monster Lolita novel or something. It's never happened. Nabokov didn't think that way.
Well, we did have the castrati in Italy a couple hundred years ago,
Okay.
so they could sing higher. I mean,
Pretty
but that was not a medical choice.
Pretty bad.
That was just, that was really bad.
I mean, frontal lobotomies, but they actually thought they were helping. Now, that was mainly women too. You're probably aware.
Yep.
A large majority of frontal lobotomies were on women, and it calmed them down. Ovurectomies is another example. That was back in the 1800s. They removed the ovaries of women of a certain age to stop. That's why they called it hysterectomy, to stop their hysteria.
Yep.
See, it's so there's some craziness out there, but I've never seen. I don't know of a good example of this being done wholesale, where the whole medical community, seemingly, or a lot of it anyways, adopted it without even looking at it. It's so odd to me that a surgeon could take a knife and cut off a teenage girl's breasts, after they go to one counseling session for 2 hours and self-diagnose. The whole thing stinks from beginning to end. It's awful.
What blew me away is we've got a surgeon down in Miami who uses TikTok and Instagram to
Yeah.
market mastectomies of healthy breasts as safe, effective, and medically necessary. There's another one in Charlotte, North Carolina, and until recently, she was proudly showing you before and after and giving you the demographics. This is a 14-year-old before and after, and I saw 14, 15, 16-year-olds where she's proudly displaying what they look like before and after. And this is going back about 3 years, maybe 4 years, I started seeing this. And I couldn't believe that this woman is proudly, putting it up there. It, there's something very diabolical about this, and kids can find this stuff. Now that same doctor, now you have to, just like an alcohol, vodka thing, you have to verify you're 18. Okay, go ahead. No, a little kid's gonna go, yeah, I'm 18, bang, and then go in and look at the pictures. It's horrible.
Yeah.
It's horrible.
This is lunacy. But this tells me, going back to my question, this tells me that those attorneys that are representing the defendants, the clinicians, on some level believe that their clients have a valid.
Well, they might believe they have a valid legal defense.
Yeah.
In other words, they might believe, well, we have an argument. Maybe it's not a slam dunk, but maybe we've got a argument, and you usually handicap it. I got a 30% chance of winning the motion to dismiss the fraud because maybe they're not going to be able to prove intent or something. I'm using very hypothetical here, not just. Yeah. Let's not call it the North Carolina case because that's ridiculous. It just any of these cases that they should have known better, so it's fraud, and so I can certainly argue the legal point that. And I'm certainly going to that it's not fraud. The evidence doesn't rise to prove fraud, and argue the cases. And I might even say, Judge, I'm not even trying to defend the action overall, the ethics or the moral of it. What I'm trying to say is legally, this defense doesn't, this A plus B equals C. Same thing is true for, of course, statute of limitations. I mean, it's easy for him to argue that. Judge, I'm not arguing that something wrong wasn't done. I'm arguing statute of limitations is passed, and you need to dismiss the cause of action. So people have to grapple with their own morals and ethics on whether they can do that in a really bad case involving child mutilation. I'm sorry, I think that's what it is. But I'm not ready to jump to the conclusion that all the defense lawyers are, acting with bad intent. I would hope that what they're doing is saying, look, if this survives summary judgment, if this case gets to a jury, and where there's a risk that it will because its behavior and the evidence is so extreme, and this is such a unique point in history when this has been allowed, that if it gets to a jury, we could absolutely get beheaded in front of a jury. I hope that's what they're advising their clients, because that's what I would be advising my clients.
I agree. As a defense lawyer, I agree. Absolutely.
So at that point, is it too late to say, oh, we changed our mind, we're going to settle? Or can they do that at that point?
Or they can do it anytime.
You can settle anytime. You can settle halfway through a trial.
Oh.
You settle with the jury out.
You can settle
after the jury comes back because it goes up on appeal.
Exactly.
We're going to appeal the big verdict.
Yep. Yeah. You can settle anytime. You're on appeal. Let's settle. Fine.
It's just a contract. The plaintiff lawyer picks up the phone and calls the defense lawyer and says, "Hey, man, we'll take whatever, 2.3 million to settle. I know you were saying you wouldn't come up that high. You were at 1 million. I was at 6 million. But look, if you come up with 2.3 million dollars by 5 o'clock tomorrow, we're done. Send me a settlement agreement."
Mm-hmm.
That's the way it happened.
Oh.
Yeah.
Okay. Well. So I know that this strays from our detransitioner topic, but I think people are wondering about other legal actions. Like, are we ever going to see Rachel Levine, former Assistant Secretary of Health and Human Services, will Levine ever face legal consequences? He was an enthusiastic promoter of transing kids, and we learned from the Alabama Garmetti brief that he pressured WPATH to drop the age minimums for all interventions except for phalloplasty. So this wasn't evidence-based. This was a political move, probably to avoid doctors getting sued and to keep being able to harm children and vulnerable adults. So does he have any legal liability? Does he just get to walk away with this nonsense? Dangerous nonsense.
You're not gonna like my answer.
Yeah.
I know, me too. I'm with you, Kevin.
They have a. I mean, the government. The politicians have immunity. They have absolute or qualified immunity for discretionary acts they commit. They decisions they make and policies they push. It's very hard to sue anybody. You would have to. You would really have to say that the actions did not qualify as immunity, did not qualify as a governmental function, did not require his legitimate judgment. You'd have to somehow prove that he had just totally infiltrated, wasn't trying to help anybody, and was trying to harm everybody. It'd be like proving a murder crime or something. I just think it'd be very hard to do. Immunity is very broad.
Yeah, I think reputationally, that's the only thing that's going to potentially impact him. That's it. But I there's no civil cause of action.
No.
And I agree. Immunity, even if there wasn't immunity. Rachel Levine, so I'm a parent whose kid, went down the rabbit hole and came out and went, what did I do? No, Rachel Levine did not counsel my kid, did not convince my kid to do this. Rachel Levine's just up there. And no, Rachel Levine gets to skate off or reputationally suffers. And yeah, that's
Yeah.
an unfortunate.
Yeah, and that's apparently not happening because Smith College is.
Oh, I know. Yeah.
Giving him
Thank
a
you.
kind of honorary degree, and then he's giving commencement speeches. Terrible. Okay, what about WPATH? I mean, could someone theoretically sue WPATH? It's an organization. They claim to be experts. They are the ones who put out the bogus standard of care.
Yeah, they can be sued. Yes.
Kevin, do you think, because I thought about this question.
They enjoy no immunity. None of them do, by the way. American, Psychiatric Association, Endocrine Society. No, they're just private organizations.
So I could see them being third-partied in. You see what I'm saying? So
yeah.
When I say this, folks, okay, you sue a doctor directly, and the doctor says, well, I relied upon what WPATH said. And that doctor brings WPATH into the lawsuit. I'm not certain that a detransitioner could sue WPATH directly, but I could see a doctor who says WPATH had quote unquote these standards of care. I relied upon them. I'm bringing them in. How do you see this, Kevin?
Well, I think the flow chart you just laid out is the most likely one, right? That a doctor, a defendant can bring somebody else in if they're basically alleging that they are also at fault or liable, or they caused the harm along with them. So it's a contribution or indemnity action is what they call it. And you can sue. So a doctor can sue them saying, look, I relied upon what you put out there as a standard of care. And so you're liable as well. If they find me liable, you're liable. Now, it's either you're totally liable, that's indemnity. The harm flows through me to you and you owe the entire verdict, or you owe in contribution, meaning you're joint tortfeasors and you each owe 50% or some other amount that the jury sets in blanks on a jury verdict form. I do think you could sue WPATH directly. The facts would have to exist. The causation chain would have to be there. The WPATH's main defense would be, well, we didn't actually treat them, and we have disclaimers. I assume they have some sort of disclaimers.
Right.
I know Endocrine Society has disclaimers. To have disclaimers to say this is not a standard of care, although the rest of it sounds like it's a standard of care. I think we're going to get to the point where WPATH is sued directly. I agree that there's an additional causation link there. That's the medical care provider who can exercise their own independent judgment. So it makes the cause of action a little more difficult. But I think the way WPATH has held itself out and suppressed studies and results of studies, like with Johns Hopkins, they're just digging themselves deeper. It starts to look really bad. And when it starts to look really bad, you can sue them. They enjoy no immunity.
I agree. I think when you see practitioners that have the WPATH logo on their websites, I think that implicates them.
Hmm.
I mean, if I assume most of your listeners know what they did with John Hopkins, but just Google it. John Hopkins still didn't release all the studies. They released what, one of 4 or 5?
Yeah, well, let's fill them in. That WPATH had Johns Hopkins suppress the data on some systematic evidence reviews that they commissioned. So I think they released 2 out of several.
Right. They were going to be bad. They were going to conclude that there was, what came out is that John Hopkins indicated they were conclude that there were low evidence, low quality studies supporting it. It wasn't, up to what the result that WPATH wanted. So this is at the heart of medical fraud,
Yeah.
to me.
Yeah.
So you suppress the result of a study because it doesn't comply, it doesn't support the standards you want to pass for the next revision of your, standards. Yeah, I think it's pretty bad. That's my opinion. Sounds really bad.
Yep.
We see that. So I'm going to switch over to Themis a little bit. How hard is it to find attorneys to take these cases? We know Lemaitre and Campbell, Payne, Miller Payne, but is it hard? I think, Kevin, you had said in our discussion last month that the majority of plaintiffs attorneys tend to be Democrats, but then Democrats like the American Trial Lawyers Association supports pediatric interventions.
Yeah, so the bulk of the plaintiffs bar, which is now called the AJA, not ATLA, I think it's 90 something, 93, 94% of them contribute to liberal left causes or Democratic candidates or Democratic candidates. And they also form all kinds of PACs and stuff too to influence. They are a notoriously left organization, right? And really attorneys in general, because the ABA, American Bar Association, has been very liberal too. I'm sure you've seen some of the stuff it's put out, including on gender care stuff. So just super pro gender care. So they about 70% of lawyers overall support Democratic left-leaning candidates. So yeah, I do think it's had an effect on the ability to get support for bringing lawsuits, because most of the plaintiffs' bar is ideologically, or was 2-3 years ago, right? Ideologically, let's say 2 years ago, ideologically opposed to this type of action. This was a major division point, as DIAG should know. That's part of your name. Is almost all the Democrats were very pro-trans care. They just totally bit through the hook on it, and so the lawyers were, of course, going to be the same way. They're very left-leaning, and I know it's hard to think about right now, but if you go back 2 years or even a year, you could not even discuss this. I couldn't discuss it with fellow lawyers. Like, hey, what do you think about this? Do you think that, at my law firm or at legal, anywhere, any group of lawyers that I don't personally know as a friend, or because it was such a verboten topic. It's like you're Hitler if you bring it up and discuss that. Hey, I don't think this type of care is right. So yeah, I think it's been very difficult to get attorneys who are willing to sue doctors based on gender affirming care. Now that might be changing, because I do think a sea change is occurring, but yeah, I think that has hamstrung the ability for transitioners to find lawyers to bring lawsuits. Yes.
I agree, Kevin, and I hope.
Detransitioners.
So,
Go ahead.
I come from it. Okay, I'm going to go back to my daddy. My father was a member of the Association of Trial Lawyers of America. As a child, we didn't take vacations. We went on the ATLA convention route. And my dad, when I was just a little girl, 9, 10, 11, 12 years old, brought me into the convention the conferences to learn how plaintiffs' lawyers shared information. I'm old enough to tell you that they didn't have thumb drives or any websites. They had mounds of deposition transcripts of all the experts and how they could attack them. His membership number was 1492. In 2006, when the ATLA changed their name to the American Association for Justice, my father at the age of 82 said, "This is bullshit." He said, "We're trial lawyers. We don't own the word justice." And he retired his number. He threw it back at them. And by then, I don't know how many tens of thousands of members they had. And he was a Democrat, merchant marine war veteran, from World War II. And so that's the kind of Democrat I've been raised to be. And so, he died before COVID in 2020. And I try to channel him, like, what would you do, Dad? What would you do today? How would you represent them? Because he would not have this. He would not have this as a member of the AAJ. He'd be a totally different kind of trial lawyer, and he would have taken on this cause. And I hope that we have plaintiffs' lawyers out there that are sick and tired of buying into the nonsense, that this is care. It's not care. So, sorry, I'll get off my box right now and stop talking about my dad, but the ATLA really triggered me.
Well, the AGA I still call it ATLA too, but the American Trial Lawyers Association or the AGA, they may come around. There's a lot of good plaintiff lawyers out there, ethical, moral people who I'm sure this bothers, and hopefully they come around. And hopefully, as the sea change happens here, you're allowed to talk about it, and there's consciousness brought to the issue, right? And some of these bad facts keep coming out, then hopefully, momentum will build. It'll snowball. That's the way litigation works.
It's true. I mean, it's how the opioids, right? How we got there. That's the most recent thing. It's going to happen.
Well,
I'm convinced it will.
Tobacco cases were dismissed for 30 years.
Right.
I hope it doesn't years.
Yeah, 30 years. They started bringing those in the 50s, and they didn't get a breakthrough till the 90s or 60s.
Asbestos also took decades.
Yeah, it took. The first lawsuits were in the early 70s. A lot of those were dismissed, and it wasn't until kind of the late 70s, early. That had about a 10 or 12-year run, to my memory. Okay, I'm not looking anything up before it started getting footing.
Yep.
I want to make sure we have time for questions, so I'm just going to. We didn't talk about the Texas insurance bill directly, but I think we did talk about the impact on these costs and what that's going to do, because obviously, if doctors are not have to, so the bill ensures that if you're an insurer that covers transition intervention, that you are also responsible to cover harm from those interventions. It doesn't matter your status, your identity status, if you're detransitioned or you still consider yourself the opposite sex or no sex or whatever. The clinicians still have to the care is covered. So that would over cost barrier for some of these people to get some kind of decent medical care. But I assume it's the same kind of cost burden that will frighten people about providing this care in the first place, although really it's the most reasonable thing. I can't believe that Democrats are arguing against this.
Yeah, there's a big disconnect there.
Yeah, it makes perfect sense. If somebody is, again, I think it goes back to vulnerability and need for the care. And if they were vulnerable and got care they shouldn't have gotten, if you want to call it care, they had certain interventions and they need, medical care to right the ship, to get back at least some of what they lost. I don't know why medical insurance wouldn't pay for it. It's a medical need. This is actually a medical need, right? My body physically has something done to it that needs to be fixed. That is medical care.
Yeah, it's mind-boggling that it was such a big, long fight to get that passed, but
Yeah,
yeah, help other states
certainly agree.
follow.
Certainly agree.
Okay, so I'm going to ask you one final question, and then we'll take listener questions. I know we don't have that much. Any prediction when the dam is going to break? I mean, are we looking at another 10 years of kind of back and forth, or what we're seeing now?
I don't think it's 10 years, but I know that for us to wait for significant legal developments and results in just the first wave, and that's what we see here. This is the tip of the spear. First wave of cases being filed, right, by just a couple of firms before the ox begins to fall, or you have to rock the Coke machine a few times when you tip it over type analogy. That you're going to have to wait several years to see these results come in. Now, I do think within 6 months or a year, it's going to be pretty key to see some of the initial rulings, right, and the initial arbitration results. And we may even get a trial within the next year, or some significant settlements that aren't confidential. That I think we're going to see those data points maybe even within 6 months. We'll get some significant rulings by the fall. I know some of the cases are teeing them up for the fall. But as far as us seeing, more than just a smattering, more than just one or two results, you're probably talking several years. I mean, I think the arc is 3 to 5, 6, 7 years to see how these things start pouring in.
110%, 110%. Everything you said, I'm with you on that.
Yeah, it's
Absolutely.
It's a long haul. I know that is a blink of the eye in the litigation world.
Yeah, it is.
Yeah.
Yeah, and I feel for the plaintiffs that have to go through this. And that's why it's important for the plaintiff firms to hold their hands and say to them, just hang in there, hang in there, hang in there. This is really, really difficult. It really is. And, 3 years ago, I wasn't sure this was going to happen, and here we are. And so I think once it starts happening, you're going to see the cascading effect, especially with states that are expanding the statutes of limitations, that are allowing non-traditional med-mal cases to go forward, that are carving out exceptions for statutes of limitations or repose. I should say just repose. It's going to be interesting. And I also think that the federal legislature is taking a look at this as well. So I think it's going to be a perfect storm. Also, early on tonight, somebody was talking about funding for this stuff. There are venture capital firms, just as they did with the opioids and others, like the Roundup cases and things like that. They're looking at these cases too. So it's not going to be in the next 3 to 5 years, but I predict within the next 10 years, venture capital is going to want to jump in on this. Because look, if you look at Reddit Detrans, there are over 55,000 people reporting how they have regretted, or they know people who regretted their transition. 55,000, okay? And those are the ones who are willing to put that out there. So I agree with Kevin. I think we just need to keep an eye on this, and I hope that Democrats, for an informed approach to gender, when we start seeing results, we do this again. I hope that we have more results to report to everybody, and I'm really happy that everybody who tuned in did tune in.
Yeah, we'll definitely do this again because there'll be more to report on. One question that I saw about class action suits, whether or not that's a feasible legal action. I could see it around puberty blockers class action suit. I don't know how it works on their medical intervention.
Yeah, I think class action suits are a possibility. I think what we're seeing here again is these individual kind of medical malpractice cases, the smattering of them that have been filed, are again the tip of the spear. So what follows them? I think class actions, which means it's a large class of usually hundreds of plaintiffs or potential plaintiffs. And there's all kinds of federal rules about what you need to be to certify classes. It's very complicated, but I do believe that other type of class actions against similar pharmaceutical companies has been wildly successful, including attorney general's actions, right, to recoup costs and damages. So I think attorney general's class actions, these are kind of multiple plaintiff suits, is what you're referring to, multiple claimant, multiple plaintiff lawsuits, are a possibility, and I think that they are going to happen against puberty blocker manufacturers and against like WPATH, and maybe even medical device manufacturers that manufacture specific medical devices that are used in the in the some of the surgeries, the bottom surgery, for example. Um, they market certain items that are specifically for that use. So yeah, people making money and profit, absolutely. I think class actions are a possibility. And I'll add this: certain states, including Virginia, by the way, has the ability, if you're 6 plaintiffs or more that are harmed by the same kind of core operative facts, you can bring a joint lawsuit. And so that's a powerful tool to be used as well against, you know, large medical care providers, large medical care systems, large pharmaceutical manufacturers, and then professional organizations. I think those are going to be the main targets of those eventually.
So if
I agree. And I need to point out something because Kevin just brought out a very important point. You have state class actions and federal class actions. Federal are going to be really, really tough because you have to have numerosity. The class has to be so large that it's impractical to bring all the members in. Commonality. They all have to have questions of law very common to their class. Typicality. The claims or defenses of the class have to be typical of all of the claims or defenses of the entire class, and then adequacy of representation. They must be fairly and adequately protecting the class's interests. And that's a really high hurdle in federal. But state court, absolutely. I think we can look at it that way. And so, let's see if lawyers are willing to take that on. Because again, as difficult as it is to bring a med mal, wow, class action, it's what they call a Rule 23. It's difficult,
Millions of dollars needs to be behind that.
pretty much. Yeah.
so for the when I think about puberty blockers, I mean, I don't know. I mean, that the drug companies are marketing it for this use. So if it's used off label, doesn't that get them off the hook for a class action lawsuit?
Totally. Absolutely. The pharmaceutical industry has been working to erode their liability for so many. And that's something that a creative lawyer has to take a look at. Because here's the thing, off label is really for rare uses. Okay. Now, if we find out that testosterone, which is an FDA approved medication for men, has, I don't know, let's think about the market share, right? But for girls, it's off the charts. Now, they're on notice that their off label drug is being prescribed way beyond what the FDA. And I have heard from people on the inside of from CVS kind of thing, Walgreens type of thing, saying, I know what's going on. I know how many girls get prescribed testosterone. What do I do? Oh, I can't talk to you. This is not what I do, but I'm glad you're keeping track of this. So let's see how that pans out. That's not going to happen in the next 5 years. That'll be in the next 10 years.
Yeah, we don't have, so specifically address what you're saying, are they marketing it? Are they promoting it or marketing it under the regs such that they can defend themselves against a claim? If it's being the other lawsuits that have arisen against pharmaceutical companies have arisen because even though they said maybe they weren't marketing them, they kind of were marketing, like with the opiates. They're actually putting
Yep.
beautiful young uh, ladies out there to help sell the product, and they get damning emails, they get damning internal communications that, well, we actually are promoting it this way or that way. I'm not saying they exist or don't exist. It's not for me to say that, but I am saying there will be a lot of discovery into this. There's going to be a lot of subpoenas, a lot of document production requests, a lot of FOIA requests. They're going to try to uncover all communications between these pharmaceutical companies, Rachel Levine, federal government, right? WPATH, what is in those documents? It's not for me to say, but we'll see what happens.
Yep. You're right. You're spot on with that. Thank you.
Okay, so our one question person, looks like we wore her out or him out. So unless somebody else wants to ask a question, we're going to wrap it up. Yeah. Okay. A big thank you to our guests, Attorney Kevin Keller and recovering attorney Kathleen Dooley. It's been a pleasure talking to both. If you haven't already done so, please join DIAG by clicking on the join button at diag.org. That's di-ag.org. Power to reach lawmakers through our numbers. It's important to show we are a silent majority who believe in classical liberal principles about science, including on the reality of sex, ethical, evidence-based medicine for all, the power of civil discourse, open dialogue, advocating for the rights of women and girls to sex-based spaces, honors and opportunities, LGBT rights, and the necessity of a compassionate, reality-based society where truth matters. Thank you again to our guests, and thank you all for joining us. Have a good rest of your evening.
Thanks.
Thank you, Diag, and thank you everybody for hanging in there to listen to us. Really appreciate you.
Wait, before you go, hold that thought. We're going to bring up, now we've got 2 requests. This always happens. I just want to say, this happens.
It's okay.
Okay, so now that I've said goodbye, let's bring up that turf though first, and then Julie Ray Goldstein in that order.
I had my hand up earlier and I left and then joined, and I think that's what did the trick. I actually have 3 questions for Kevin if he's happy to answer them really quickly. Firstly, big thanks for hosting the space, everyone. And I really think that the way that this ends is when people start losing money, because that'll just spook so many people that they just won't want to be involved in this. My 3 questions are: is there scope for suing the non-profits that promoted and cheered this stuff? Because we had non-profits going into schools and telling all the kids that could be under the wrong bodies and everything else. Is there scope for saying that delaying puberty delays the competence of a young person to consent? Because if you've taken a 12-year-old and blocked their puberty until they're 16, that isn't the same as a 16-year-old. From the purposes, I should think, of that person's ability to make decisions. One of the things is the CAS review showed that puberty blockers have an impact on IQ. How could they possibly not? My third question is there scope for saying that affirmation-only counselling was essentially a form of conversion therapy and that it doesn't meet the definition or the purpose of counselling? Thank you very much once again, and I really, really can't wait for the results of this. It's been long overdue.
All right, I'll try. Very, very good questions, very articulate. I'll try to hit them quickly. Yes, I do agree that the nonprofits that have pushed this in the manner in which they did, and we know what we're talking. I think we know on this call what we're talking about. I mean, this isn't just abstractly promoting it. It was a cult, and it was aggressive. And the nonprofits that have done that, absolutely, I believe they've exposed themselves to liability and punitive damages and all kinds of things. I think that's the second or third wave of litigation, but it could be that attorneys general pursue that more aggressively. That could be something that the federal government looks at and that states look at to sue those organizations that have promoted harm within their states and cost them money because of it. There's Consumer Protection Acts. It exists, Federal Consumer Protection Acts and state consumer protection acts, which exist for just that kind of thing, in my opinion. Number two, yes, I think it's an outstanding point, and it's made in a lot of these cases, these lawsuits that are filed, that the puberty blockers and the cross-sex hormones are psychotropic medications. They severely affect the way somebody thinks, right, and this way they reason. And puberty blockers in particular retard brain development because the brain's not being bathed in the correct hormone from ages of early teen on. And when people don't believe that puberty blockers are given to young people, you're missing the point. That's who they're given to. At stage 1 puberty, 9-year-olds, right? And this retards development of the brain, and I think affects capacity. And I think there are very good arguments to be made that the statute of limitations, this is why there should be legislation, not just on a case by case, that the statute of limitations should be extended for those youths that have been subjected to psychotropic meds that retard development of their brain. And then 2 years after they turn 18, you say, oh, you can't, it's too late to sue. Well, you're still on the medication. And even if you're off the medication, you're still way behind the curve, right? You're still way behind the developmental curve, and it's unknown now whether you're even going to catch back up. The studies, how can you know that? You can't know that now because you're going to have to. You're going to know that 20 years from now whether they can catch back up. But I think a lot of the studies now are saying no, you have retarded development of the brain, appropriate development.
Kevin, it's like pressing a pause button, and you press the button again, then it unpauses.
Yeah, what a crock that was, and they had to take that off of the HHS Rachel Levine website, right? That it was absolutely reversible. You're just pushing pause; it doesn't hurt anything. And then you see some of these people that have had their paused in interview. It's like, how old is this person? They talk like an 11-year-old. They're 20. You think you're talking to a little kid? It's really extreme. I don't think people realize what's happening. Or what has happened. So yes, and yes, I believe that the true conversion therapy is taking just a young child who is gay and
autistic. Lots were autistic.
And over 50%, right? It's the latest study. 50-something% were autistic. That was the CAST study, I believe. I don't know what the latest one is, but the autism diagnoses have really gone through the roof too. I think it was just an article in the Wall Street Journal about that. But the true conversion therapy, my conclusion would be, and this is kind of the basis of the lawsuit, the ACA lawsuit that was brought that we discussed earlier. True conversion therapy is taking somebody that is just either confused about their sexuality, young person, or a gay person, and telling them that's wrong. You need to be the opposite sex. And not only do you need to act it out, we will physically make you that. Try to unpack how many lies are in those 3 sentences I just gave. What a tangle of thorns that is. Go ahead.
It's a mess. One more quick one is sporting organisations where women got hurt. So I'll mute myself. That's it.
Sorry, I didn't catch that. Can you repeat that question and then we'll move on to Julie Ray?
Yes, please. My apologies. One more final one. Sports organisations where people got hurt. Can the people responsible for example, Peyton's very severe injuries, can they have money taken away from them? Can they be held account?
Yeah, that's a different topic. I certainly think that could be looked at. Again, that's not a medical malpractice or a medical care provider tort or the tort against a pharmacy, but pharmaceutical company or a professional organization. But the rules just changed. I know you had the big decision in England over that just a couple weeks ago. Such that now the cross participation is what I call cross participation is being banned. by a lot of the organizations. I certainly think there is the basis for a lawsuit there. I do. But I'd have to study in which jurisdiction the cause of action accrued and what causes of action exist. I am not for bringing harassing causes of action. They have to be viable, right? They have to have a basis in law and fact. But it's hard for me to believe that there isn't a legal remedy for what you just laid out for some, female being hurt by what is a male slamming a ball into their face or breaking bones in their face, shattering their facial bones, all this kind of thing that's happened.
Okay, thank you. Good questions. Julie Ray, you should be able to speak.
Yeah, I think so. So I have two quick questions over cases that were not brought up tonight. Actually, one is a really good segue from what Kevin was speaking about regarding the ACA argument, specifically that providing care constitutes discrimination in violation of Section 1557 of the ACA. There's actually one case in Wisconsin, Doe v. Lick, where it was actually ruled by the circuit court that specific cause was dismissed, and it has since been affirmed by a appeals court. I'm curious your opinion on that ruling. And then secondary, one other case that was not mentioned was the Soren Aldaco case. And that brings up the instance where now we're seeing not one, but two cases where detransitioners have had judgments ruled against them in favor of sanctions or money awards to pay to the defendants. In Soren Aldaco's case, it was taken to the appeals court, and the appeals court reversed the lower court dismissal of vacating the dismissal and sanctions and reinstated them.
Julie,
my question there.
Julie, let me stop you. You were anxious to talk about this last time too. I think you and I talked about Soren Aldaco last time, right? Was that? Let me just let you see how honest you are answering the question. Was that Aldaco case in Texas? I'm not saying it right. Apologies. Was that dismissed on the merits?
I'm not. The Aldaco case dismissed on the merits. So that one was dismissed. Actually, my understanding was that it was a bit of a screw up by the Soren Aldaco's legal team, and they misunderstood the deadline for certain filings.
Right. Well, I don't agree with that characterization, but we know it was a procedural dismissal because there wasn't disclosure of. I think it was expert reports. Wasn't disclosed in a timely fashion, even though there had been a stay because of COVID. So during COVID, a lot of courts put stays on, and so it was confusing as to when the deadline was for disclosing the experts. In any event, I don't know enough about the procedural dismissal. I've read the opinion and the appeal of it.
Did you hear the appeals?
Yeah.
Let me just stop you there.
No, I saw
okay.
it. It was appealed.
So my question is regarding.
It was appealed. The point that no, I'm trying to answer your question. Don't talk over me. It was not dismissed on the merits, and I've said that multiple times. Has there been a dismissal that attacks the merits of any of these claims? Not procedural dismissals, not dismissals where the statute of limitations has been violated or somebody missed a deadline. That's called gotcha law practice. That doesn't address the merits of the claim, the justice of what was done or the injustice of what was done to the person. So that's my point. So is there a ruling in Aldaco? I don't think you're asking a question.
Yes.
I think you're making an argument. There was.
Well, actually, I have a question about it.
There was a ruling dismissing on a procedural issue that is still being appealed. I know that. And
the appeal was ruled upon, actually.
No, I know, but it's still, there's another appeal. I know it was appealed and there was a ruling on the appeal. It was appealed and it was overruled and the case was reinstated, and then that was appealed and then it was dismissed again more recently, I think in March, I believe. And then now it's also being looked at to see whether there's other causes of action that can be brought or whether those items can be appealed. All these things got to work themselves through the courts, right? And there are going to be some cases that are lost, and there's going to be some cases that are won, and there's going to be some procedural victories both ways. and all the cases have to go up on appeal. So the one you mentioned, I don't know. I know you just mentioned the ACA case is what you mentioned first. I want to go back.
Dovey Lake.
Yeah, I want to go back and address that real quick. Those have to be appealed. These cases may have to be appealed to the United States Supreme Court. So the case we talked about, the ACA case we talked about earlier, that's going to be appealed to the First Circuit. I don't know what the First Circuit's going to do with it. Okay, I don't know what the Court of Appeals is going to do with it. First Circuit's very liberal, all Biden appointees. I don't know what they're going to do. But I know that eventually these cases are going to end up in the United States Supreme Court, and we're going to get rulings that are actually, legitimate on the merits, final decisions. And so I would hesitate celebrating on both sides, celebrating any early victories, popping any champagne corks until it all plays out.
So actually, that brings up another quick question, if I may, regarding the Dovey Lake case, because that was a state appeals. Can that actually be appealed to the Supreme Court of the United States or just to the Supreme Court of Wisconsin? Because my understanding is that that's a state case. That's not that can't be appealed federally.
The one I was discussing, I don't know that case, the Dovey case. I know that the ACA case, of course, was a federal case in federal court, and so that's going to be appealed up through the federal courts, including the Supreme Court. I will tell you, just from my general knowledge of constitutional law, and I apologize, I don't know the specific answer to your question, Julie, it could be that if it only involves state rights, right, state substantive causes of action, that it ends at the state Supreme Court. And I don't know what the standards are for when the appeals are exhausted in the Supreme Court of that state. But I do know that if the question involves a federal right, then it can be appealed to the United States Supreme Court. And a federal right includes all constitutional rights, including due process, civil rights. So a lot of cases were lost for years, including race discrimination cases at the state level. And the state Supreme Courts overruled and slapped them down for years in the 50s, 40s, 30s, until the United States Supreme Court started taking them up in the late 50s, early 60s, and righted the ship. These things take time.
Okay, fascinating questions and discussion. With that, I think we'll call it. Again, thank you to both of our guests, Kathleen and Kevin. Thank you all for joining us. Have a good rest of your evening. Bye-bye.
Thanks, everybody.